However, in this case, an exercise to determine whether the SMA is unconstitutional because of under-inclusiveness would be futile because of the limitations of this court's power to grant a remedy. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine. Parliament has access to varied sources of information and represents in itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the CARA circular. Page 153 पे correction था. The understanding of the Constitution, then I've said the goal of self-development and what it means to be human. This understanding of the Constitution is substantiated on a reading of Part 4 of the Constitution. To illustrate, Article 38 states that the state shall strive to promote the welfare of people. Then I've referred to Article 42 and Article 47. The Constitution, through both positive and negative postulations, inter alia capacitates citizens in their quest to develop themselves. Such capacity building enables them to achieve their full potential in both the private and the public space and to be happy. The Indian Constitution, unlike, say, the South African Constitution, does not expressly provide that the Constitution seeks to improve the quality of life and free the potential of each person. However, such an understanding can be gleaned from the provisions of Part 3 and Part 4. Thus, one of the purposes of the rights framework is to enable the citizenry to attain the goal of self-development. Humans are unique in many respects. We live in complex societies, are able to think, communicate, imagine, strategize, and to do more. However, that which sets us apart from other species does not by itself make us human. These qualities are necessary elements of our humanity, but taken alone, they paint an incomplete picture. In addition to these qualities, our ability to feel love and affection for one another makes us human. We may not be unique in our ability to feel the emotion of love, but it is certainly a fundamental feature of our humanity. We have an innate need to see and to be seen, to have our identity, emotions, and needs fully acknowledged, recognized, and accepted. The ability to feel emotions such as grief, happiness, anger, and affection, and the need to share them with others makes us who we are. As human beings, we seek companionship, and most of us value abiding relationships with other human beings in different forms and capacities. These relationships may take many forms: the natal family, cousins and relatives, friends, romantic partnerships, mentors, or students. Of these, the natal family, as well as the family created with one's life partner, form the fundamental groups of society. The need and ability to be a part of a family forms a core component of our humanity. These relationships, which nourish the emotional and spiritual aspects of our humanity, are important in and of themselves. Further, they are as important to self-development as the intellectual and eventually financial nourishment we receive through education. Self-development cannot be measured solely in terms of educational qualifications and financial capabilities. Such a description is to forget what makes us human. It is insufficient if persons have the ability and freedom to form relationships unregulated by the state. For the full enjoyment of such relationships, it is necessary that the state accord recognition to such relationships. Thus, the right to enter into a union includes the right to associate with a partner of one's choice, according recognition to the association, and ensuring that there is no denial of access to basic goods or services, which is crucial to achieve the goal of self-development. On the other hand, the state could indirectly infringe upon the freedom when it does not create sufficient space to exercise that freedom. A formal associational status or recognition of the association is necessary for the free and unrestricted exercise of the freedom to form intimate associations. Needless to say, there may be reasonable restrictions on this right. However, other than legally valid and binding restrictions, the right to intimate associations must be unrestricted. The state, by not endorsing a form of relationship, encourages certain preferences over others. In a previous segment of this judgment, we have discussed the tangible and intangible benefits of recognizing relationships in the form of marriage. While the tangible benefits of marriage are traceable to the content of law, the intangible benefits are secured merely because the state recognizes the relationship through the instrument of law. Intangible benefits in the form of expressive advantages exist irrespective of the content of the law. Even if the law does not grant any special material benefits to a relationship, the relationship would still be considered to be legitimate in the eyes of society. the freedom to choose a partner, and the freedom to enjoy their society, which are essential components of the right to enter into a union and the freedom of intimate association, would be rendered odious if the relationship were to be discriminated against. For the right to have real meaning, the state must recognize a bouquet of entitlements which flow from an abiding relationship of this kind. A failure to recognize such entitlements would result in systemic discrimination against queer couples. Unlike heterosexual couples who may choose to marry, queer couples are not conferred with the right to marry by statute. To remedy this, during the course of the hearing, the Solicitor General of India made a statement that a committee chaired by the Cabinet Secretary will be constituted to set out the rights which will be available to queer couples and unions. The committee shall set out the scope of the benefits which accrue to such couples.